Hello, welcome to the NYU Law Forum. We are really excited about today's event, which is called The Administrative State in Turmoil. As you all, I'm sure many of you know, it's great to have so many students, also alums here listening. This was a high water Supreme Court term in terms of cases that potentially affect the shape of administrative law. I'm particularly excited because, from my perspective, I live in some of these debates, but I'm Catherine Sharkey here at NYU Law School. I'm joined by Noah Rosenblum, who's not only administrative law specialist, but also a legal historian, so has sort of historical perspective on some of these debates. A theme seems to be the US Supreme Court giving very enhanced scrutiny of what federal agencies are doing. And so instead of this only being a kind of academic discussion, what we're doing in the forum, which is typical but maybe not at this spectacular high level, is we've gotten two people who kind of are incarnate of how these things play out in the real world. So Sam Bagenstos is the General Counsel at the Department of Health and Human Services, an extremely significant federal agency and a wealth of knowledge that he's going to be able to share with us on these debates. And Boris Burstein, who's a former government official in OIRA and Office of Management and Budget, and now represents sophisticated clients from his perch as a partner at Skadden private law firm. So we're really excited to pitch some questions to each of them about some hallmark cases. The ones that sprung to our minds were the Loper-Bright decision, the one that led Chevron come tumbling down, the Jarkissi decision that kind of aims its blow at the SEC's internal quasi-court proceedings, then Corner Post, which you might have heard about, which seems to encourage further challenges to agency regulations by specifying a kind of tolling of the statute of limitations period. And finally, Ohio versus EPA, where the court may have lowered the bar for arbitrary and capricious APA challenges. So 4 kind of monumental decisions, but we're going to try to have this be an interactive discussion with our guests here to see how this will play out in the real world. And then we will also have Q&A at the end. Great. So without further ado, let's get started on Loper-Bright. As I mentioned, and most of you know, this case declared that the monumental Chevron case was overruled. I wrote down there's some choice lines. So Chief Justice Roberts says, quote, "In the business of statutory interpretation, if it is not the best, it is not permissible." So what's going on there? It's this idea that there's a best reading of a statute, and no longer will we abide by the Chevron two-step, where we have this kind of legal fiction that if there's ambiguity, the authority was delegated to the agency to decide the interpretation. And then one other line I wanted to bring up from Justice Elena Kagan in dissent. She predicts this ruling will, quote, cause a massive shock to the legal system. And so I wanted to use sort of both of those remarks as framing to talk about the implications. So Sam, if we could begin with you, if you could just tell us maybe how your world has reacted to this decision.
Yeah, I mean, a couple of things, and it's really great to be here, and sort of amazing that you can get so many people to come to a presentation about administrative law, which is very different than when I was a law student, I have to say. So number one, the reality was that Chevron wasn't a thing in the Supreme Court for the last, nearly a decade. The Supreme Court had not upheld a disputed agency interpretation of a statute under Chevron since 2016. In this entire presidential administration, the Solicitor General's office had not relied on Chevron at all in a case in the Supreme Court. We were still relying on it some in the lower courts, but the advice that all of the general counsels across the government were giving our clients was, don't think Chevron is there for you. You should be acting in a way that is going to survive if the court is going to determine what is the best interpretation of the law. So there's a degree to which, it was already priced in. We knew this was happening. I think the other thing that's important that may lower the temperature a little bit about Loper Bright is, it's important to understand just what Chevron is. I mean, Chevron took on this sort of, aura of anytime an agency does a thing, whatever that thing is, courts ought to be deferential toward it. But that's not really what Chevron was about. Chevron was about something very specific. When an agency is resolving an ambiguity in a statute, then if it's reasonable, the way the agencies resolve the ambiguity, that is something that gets deference from a court. So it wasn't about a determination that an agency makes within an expressly delegated area of policymaking authority. It wasn't about fact findings made by agencies. It wasn't even about the sort of day-to-day application of accepted legal standards to facts by agencies. It was about this very specific thing. And, in a world where Chevron existed, pre-2016 at least, in a world where Chevron existed, it became pretty easy for agencies and folks defending agencies to kind of mush all that stuff together and say, Chevron defer. I think in the post-Loper Bright world, we're going to be doing a lot more trying to focus on, well, what kind of question really was it that the agency was engaged? What was the action the agency was doing here? Was it really interpreting a statute, or was it doing one of these other things? And are we under a statute that, the Chief Justice explained, the APA says agencies don't get to decide what statutes mean, courts get to decide what statutes mean, but a statute could say, and many statutes do say, the agency gets to decide what this statutory term means. Or they do say, this is an area we are delegating to the agency. And so are we in one of those statutes instead of kind of the normal APA land? And I think those are the questions we're going to ask. But I think once we sort all that out, yes, it's important as a symbol, it's important as a signal from the court about how they feel about the administrative state. Doctrinally, Loper Bright's not going to be as important as all the shouting is really suggesting.
And just a quick follow-up before we turn to Boris, if we could just be very specific. So first, I'm going to ask Boris a little bit about this. There was a case that the Supreme Court granted cert, and then they decided there was no standing, where the FDA was being challenged by the Alliance for Hippocratic Medicine over mifepristone, an abortion drug. And there are now pending challenges about the rulemaking the FDA has done for laboratory-developed tests. And I guess it just raises a question of, are there particular types of challenges, for example, that would merge kind of the expertise policymaking of the FDA with statutory interpretation, like what's a medical device, what's a drug, and that we should maybe be worried, even if the hype is great in that domain, there's some cause for thinking that some settled deference towards the FDA might be unsettled?
Well, I would say, Kathy, that this is a good example of just what just the kind of parsing that I think Sam was referring to, and with which I very much agree. Because even as the Supreme Court said in Loper Bright, well, it's the obligation of the courts, without deference to the agencies, to determine what the right reading of the law is. It also tipped the hat to the expertise of the agencies in determining what the facts are. And so in this review of agency rulemaking, I think there's going to be a lot more attention to what exactly here is law and what exactly here is facts. And you can see how FDA's approval of this particular pharmaceutical, which involved termination of pregnancy, and the questions are significantly about the effectiveness of that pharmaceutical or particular use cases of it. A lot of what the agency is doing is really developing facts where one might say courts have somewhat less to contribute before Loper Bright and after Loper Bright. And I think there's going to be a lot more attention to that distinction. And I think I should say that this this case, the mifepristone case, is also a good illustration about it's a good caution against oversimplifying this problem as regulatory agency versus the regulated entity. And if you just put yourself in a position of a pharmaceutical company, do you really want to live in a world where third parties are able to challenge FDA approvals of pharmaceuticals with a relatively low threshold and for judicial deference to the agency? Whom is that world really good for? And I guess I'll just say, Kathy, you mentioned Justice Kagan's massive shock quote, and was definitely not the kind of person who would second guess Justice Kagan on questions of administrative law. But I think our ability to predict what Supreme Court decision is going to actually have a massive practical effect downstream in the courts is like really, really limited. I don't think, I guess I was alive, but not very much. I don't think when the court issued the Chevron decision, anyone thought it's going to be the most cited case, at least for a while, in administrative law. I think that's not a problem limited to administrative law. Happened to be clerking during the year the Supreme Court decided Twombly for the author of Twombly. And I can tell you no one thought that that's going to be a case that every law student's going to know. And so exactly how the lower courts are going to absorb Loper-Bright and whether post-Loper-Bright determination of what's the right interpretation of a statute is going to be that different from the Chevron step 1 analysis of what's the clear meaning of the statute. I just think that's yet to be seen.
Great. Noah?
So we've been talking about Loper-Bright and the future of deference, and so I just wanted to shift for a moment. The deference question, as Sam alluded to, often comes up in the rulemaking context. And I want to shift to the other major form of agency action, which is adjudication, which was the subject of jarcossy. So in that case, the court seems to have limited agencies' internal adjudicatory powers. Before jarcossy, if the Securities and Exchange Commission wanted to sanction a broker-dealer for violating the securities laws, they could pursue an enforcement action in front of an adjudicator inside the agency, what in administrative law we would call an Article I adjudicator. But in jarcossy, the Supreme Court introduced some new distinctions, and at least as I read the case, it seems to have said that if an agency wants to inflict a punishment that is usually available in a common law court for a crime or something like that, then the agency has to go in front of a regular judge to do it. They have to go to an Article III adjudicator, not an Article I adjudicator. So I have a couple of questions, Sam and Boris, for you. Let me start with Sam, if that's okay. There's been some debate, at least in my world, about how big of a difference this case will make. So the justices didn't write about how it's a shock to the system, but law professors have written about whether it's a very big deal or really a nothing to see here kind of case. Now, the minimalist position might be something like, look, this isn't really that important. It doesn't apply to a lot of agencies. In fact, maybe it's really just about the SEC and this one weird change to the law that gave the SEC these adjudicatory powers. They used to have to go to court to enforce their actions anyway. So that would be the minimal. At the other extreme, the case might be read to undercut enforcement pretty severely, maybe by chilling enforcement action. We don't really know how far it extends, so better not to bring this case. Or by raising the costs of enforcement. If you really want this remedy, now you're going to have to go to an Article III judge, not an Article I adjudicator. So I was just curious, where do you fall on this spectrum? Do you think this is a big deal case that's going to change how agencies act, or a pretty small case, nothing to see here, at least if you're not the SEC?
I think it's a pretty big deal. So what are we, 3.5 months since jarcossy was decided? Already my own agency is defending or has defended at least 10 jarcossy challenges in various fora, and likely more are to come. In part, that's because the particular tool that was used by the SEC in that case was a civil monetary penalty, which is an enforcement tool that agencies across the federal government use, and that Congress continues, even post-Jharkhasi, to put into legislation. I mean, it's kind of like post-Chadha, they keep putting legislative vetoes into legislation. Post-Jharkhasi, they continue to put civil monetary penalties into legislation. That is the way that, in my own agency, it is the only way, or at least the only effective way we have of enforcing a lot of our authorities. It's not the only way we have of enforcing all of them, but for some of them it is. So yes, I think, what exactly Jharkhasi means, people don't know, right? It seems clear that any time an agency uses a civil monetary penalty through an administrative adjudicator, which again, agencies do all the time, we at least have a Jharkhasi argument. And then the question is really going to be, does the penalty vindicate a public right under the public rights doctrine that the court, stated is a thing, has been a thing for a while, but didn't really give much of an explanation of what the thing is, much of a description of what the thing is, right? There were some lists of, well, here are some things that have been called public rights in the past. And a general tone of, and we're kind of skeptical about calling much more than that a public right, and we're not even really sure what fits within the categories we've just articulated. So I think we have, in all of those cases, an argument now. So as far as effects on the system, Loper Bright is cited against us in every case against us now, often cited very high up. I have not seen any difference in the way the litigation proceeds, rounding error aside, because of Loper Bright. We're having the same arguments we had before. We're losing the cases we would have lost before. We're winning the cases we would have won before. Jharkhasi, I think there's much more question about. And then, there's the remaining question of how far does Jharkhasi extend beyond the civil monetary penalty context, which again, litigants are pushing, and this is something that the courts are going to decide, but the potential implications are quite significant.
Boris, I'd like to pick up where Sam left off, which is sort of where the litigants are pushing. And this picks up on your answer to Kathy's question, where you pointed out that large pharmaceutical companies might not actually want some of the world that the Supreme Court and Loper Bright is maybe pointing towards. I have a similar question about Jharkhasi. So one of the arguments I've heard for why it might not have been that big a deal was that actually private regulated parties might prefer to go in front of agency adjudicators and might consent, at least if they're allowed to under the law, to that kind of adjudication. And so this raises the question of where the private regulated parties see themselves. Is it your sense that they would prefer to go in front of a specialist agency adjudicator rather than a generalist judge? I'll just point out, since Professor Sharkey observed this as a legal historian, this was one of the things that led to the development of specialized adjudicators, that large regulated industries might actually prefer to go to the agency rather than a judge, certainly rather than a jury. So would that still hold, or is it your sense in your practice, insofar as you're allowed to speak about it, that parties are trying to widen the opening that Jharkhasi has created?
It's hard to know, and my guess is that if you survey 100 lawyers about this, you'll get 200 opinions. But I will say, in my own personal experience, the ability to go into federal court is an important tool. Now, different clients have different sensitivities to conflict in an enforcement proceeding at all. And in different contexts, different clients might prefer to be in a specialist tribunal as opposed to before a judge, let alone a jury in a federal court. But again, you asked me about my particular experience. I mean, if we just draw an analogy to something that lives a little bit outside of the administrative adjudication system. I mean, I actually make most of my living as an antitrust lawyer. And that's generally an area where you always have an option to go to federal court. And for clients willing to do that, that has been an important leverage point. Because while we're living in a time where, for better or for worse, the antitrust enforcement is extremely aggressive, the success rate of at least the federal antitrust agencies and courts has been pretty mixed before judges and really mixed before juries. And so the ability to at least credibly threaten that you will take the case all the way there is a pretty important tool.
So we're going to pivot to the corner post decision, but I think it fits in broadly thematically with, we could, in a nutshell, think about how corner post basically allows companies to challenge rules long after they were issued. And it might lead to, and maybe Boris will start with you and then I'll come to Sam, it might lead in your practice to seeing kind of an upsurge in certain types of challenges to agency rules. So it was interesting before when you mentioned, pharmaceutical companies maybe having an interest in kind of settled deference to the FDA on scientific, technical matters. But for other types of rules, what this decision does, right, is instead of having for challenges directly under the APA, a 6-year statute of limitation from when the rule is finalized, the period starts when the harm is realized. So that could lead to a desire to change or to challenge, right, long-standing regulations that wasn't possible before, and maybe even more strategic gamesmanship about figuring out ways to become presently harmed under a statute or under a regulation. And I'm just wondering if you could share your thoughts about that.
Sure. Just a couple of thoughts, Kathy. I think it's true that a conversation with a client about challenging a regulation that might have at one point ended simply by saying, we're out of time, can now be a different kind of conversation, particularly when, as sometimes happens to me, you're not necessarily dealing with an individual client that encountered harm at a particular point, but you're working with an industry or trade association to try to engage in some strategic litigation. You may have some choice about who the particular plaintiff would be. I think it's interesting, Kathy. You set this question up as a bit of a counterexample with where I began my talk about how sometimes an industry doesn't like the litigation. This actually, the corner post case itself is actually can be another example of the same thing. People really don't focus on what corner post was about. So corner post was about swipe fees that merchants pay when you use a debit card. And it's essentially a price-setting mechanism as between two essentially private actors, the financial services industry and the merchants. It's part of like a long-running battle. And so what corner post did is potentially destabilize that price-setting mechanism. Well, that might be a positive development for the merchants who want to destabilize it to further decrease, debit and debit swipe fees. It's not such a good thing for the financial services industry that 10 years ago lived through the litigation where the Federal Reserve set these fees, the merchants challenged it, the DC Circuit ended up upholding the Fed's regulation. So now at least everyone knows what world we're living in. Well, now the merchants are coming in and, again, 10 years hence are able to destabilize the current regulatory regime. Footnote to that is the Fed is also in the process of amending those rules and further changing the rates. And so think about advising, a client that might be participating in what, is possibly the most consequential infrastructure of our economy, which is the payment system, while the regulatory regime and the litigation regime are both moving at the same time.
Yeah, that's interesting. And Sam, what about? It's we've put you in the posture for each of these opinions so far, locating yourself on the spectrum. So maybe here too, is this one like does it induce a kind of anxiety about opening the aperture for challenges to a whole bunch of regulations in a new way, or is it? Would you anticipate, even though our predictive powers might be limited, that it will not necessarily lead to a flood of new types of challenges?
Yeah, it's hard to know whether it'll lead to a flood of new types of challenges, but sure, anyone representing an agency particularly an agency like ours, Department of Health and Human Services, by the way, is responsible for 40% of the regulations in the entire federal executive branch. So we have a target-rich environment for folks. And yeah, what we know now, and I'm not saying anything that the Solicitor General didn't say in their arguments in the Corner Post case itself. What we have now is a situation where we have no repose. Before, I think what's important to understand about Corner Post is in the pre-Corner Post world, it wasn't like if a regulation gets issued and then 6 years and a day later, the agency tries to apply it to someone, the person it was applied to couldn't defensively challenge the regulation. So in every circuit, if the regulation was being applied to you, you could raise as a defense, even after 6 years, this is an invalid regulation. What Corner Post was about was, can someone come along and essentially facially or affirmatively challenge a regulation? And yeah, now, particularly when we think about trade associations or ideologically motivated challengers to things that we do, when we combine that with the forum shopping that we have to deal with a lot as defensive litigators for the government, where there are certain districts in the federal courts where you can know exactly who your judge is going to be, and many of those judges are people who have made clear exactly what they think about my agency and what we do many, many times over. So just imagine you're sitting there in some ideological organization, you're looking at the things you don't like about what you call the nanny state or what you call woke government or whatever, and you find something you don't like. And then you create some entity that didn't exist at the time that the regulation was adopted and therefore couldn't have been injured. And you incorporate that entity in, I don't know, Amarillo, Texas, where there happens to be one judge. And then that party brings a lawsuit. Not that different, actually, from what happened in the Alliance for Hippocratic Medicine case, by the way. This is not really that stylized an example. But so yes, this could happen all the time. Now, obviously, everyone's got limited resources. It's not literally going to happen to everything, but it certainly increases, our anxiety and our difficulties in defending longstanding rules.
So we've just been talking about what happened, how you get yourself into court, as it were, and how Corner Post changes that. Just to close off our brief drive through the 4 big cases of last term, I want to talk about what happens when you get into court, which is the sort of issue in Ohio v. EPA. So for those of you who didn't follow this case, Ohio v. EPA didn't officially change any of the law in administrative law, but it did suggest something about how the old rules are being applied. So in that case, the court had to decide how likely it was that the EPA had acted arbitrarily and capriciously when it imposed a particular clean air regulation. I think it was the Clean Neighbor Plan or something like that. The case was an unusual 5-4 split, with Judge Amy Coney Barrett, one of the more conservative justices, joining the 3 liberals in a dissent. So Boris, I'd like to start with you. A lot of the commentary on the case is focused on just how nitpicky the majority opinion was in its arbitrary and capricious review here. So if I recall correctly, the majority even made some mistakes in its own opinion. It confused nitrogen oxide, which is dangerous, with nitrous oxide, which is laughing gas. But the mistake drives home just how in the weeds the opinion was, right? To explain why the EPA got this wrong, the justices had to give a disquisition on nitrogen oxide. Okay, so how did the private bar react to this? Do the regulated parties see this as an opportunity for more court involvement? Oh, look, right? First we got rid of deference. Now they're going to do extra hard look review. This is awesome. Or flip side, is it more like what you've referenced in the pharmaceutical context? Are you seeing clients anxious that this means that now single activist judges, like a judge in Amarillo, Texas, might feel emboldened to interfere with settled regulatory expectations?
I mean, again, I would always hesitate to speak for the bar or for clients generally, but I think it's very fair to say, I mean, nitpicky is a pretty good description of this opinion. And Let me maybe give you a sense of kind of where, in my more government experience, EPA kind of falls. I'm sure Kathy and Noah, you've experienced, and when you grade papers, there's like a range of work product.
I don't know what you
Maybe
mean,
not at
Boris. Our students are perfect.
Maybe not at NYU, maybe just maybe where I went to law school. And so Sam and I have both, at a prior point in our careers, been general counsel of OMB. And so we've seen a lot of work product from federal agencies and from all kinds of different agencies. And there's a range. But I would say that EPA is like a gunner in your class, right? Like it is. I mean, not as good as HHS, but it is a pretty. It has quite sophisticated regulatory capabilities, right? Like, there are a lot of agencies that don't do a lot of regulating, have not, don't have decades of experience building out an economic shop that does a lot of cost-benefit analysis and the like. It's just the reality of government. And so if you take this mode of analysis, and then you think about, well, how is this going to apply to regulations from some of those agencies? And you do start thinking, like, are they really going to pass the test? And but I don't want to be over exuberant about this, because just like I said before, there's like this what I'm told is a district judge saying, like, oh, the Court of Appeals might. Oh, maybe they'll overrule me. I overrule them every day. All right, so what are the district courts and the courts of appeals actually going to do with this? Are they going to change the way they've done business, or are they just going to nod along?
So, Sam, I sort of want to take Boris's question and put it to you and just ask, the not just the courts, but the agency, right? So how do you respond to a ruling like this? Because from a kind of formal black letter law perspective, it changes nothing. On the other hand, it does suggest that there are now 5 votes for, I think they call it fly specking all the rulings. And obviously, as you just referred to, your agency's in charge of 40% of the regs. Having to try to bulletproof your regs has got to be expensive and time intensive, so you have to make costly decisions about resource allocation. Does a case like this enter into your calculation as a case, or as an indicator of the climate?
Well, it's certainly an indicator of the climate. I mean, I think, Boris's point about the Supreme Court versus the lower courts is really important here, which is, it didn't change any of the formal rules. So this is a case that could easily be distinguished one way or another on the facts, in any other case, because the facts will just be different. The Supreme Court is not going to take more than a tiny, tiny fraction of the arbitrary and capricious cases which are pure application of arbitrary and capricious law to particular entities in any year, right? So for the most part, this is really about, for us, the lower courts, and it's lightning striking when the Supreme Court gets involved. And a lot of lower courts have been very nitpicky for a long time. And you can read a whole bunch of DC Circuit opinions. If you read that Yale Law and Policy Review blog that every week, just does a little 1-paragraph blurb about every DC Circuit opinion. I mean, you'll see some of those opinions from the DC Circuit get almost as, if not as nitpicky as the Supreme Court did in the Good Neighbor case. So that's a reality we have to live with. Now, that most of the time the Supreme Court doesn't. We can cite a lot of Supreme Court precedents. FCC versus Prometheus is my favorite, which is basically, well, the agency sort of gets to make reasonable extrapolations from the data it has, and it doesn't have to be perfect, and blah, blah, blah. And that principle would take you a long way in these cases. But there's always room for a court to be nitpicky, and they will often. Maybe one way I will take this is, we've been talking a lot about litigation, but, and a lot of my job is to work with the Department of Justice to represent HHS in court. But a huge part of my job is to advise the agencies within HHS as they're developing whatever they're doing, including the regulations. And within HHS, we have the same variance. We have some folks who are really sophisticated regulators and some folks who are a lot less sophisticated, and we have to work on that as well. But one of the things that's true, regardless of how sophisticated they are, is we'll get a rule, and this is just a dynamic that happens over and over for review within the Office of General Counsel, and our lawyers will read it carefully, will read the preamble carefully and say, you know, there's a logical gap in what you're saying, or it seems like you're only citing one study here for this crucial factual point, and it could be stronger, or you know, any of the things you might do if you're just a smart person trying to figure out if the reasoning of the agency is adequately explained and adequately supported. And invariably, the folks who we're saying that to are people who've been working on this issue for 5, 10 years. You know, they've come up with the best product they can come up with, obviously under lots of constraints. But they've come up with the best product they can come up with, and they say, come on, isn't it obvious what we mean? Or, you know, can't you just draw that inference or whatever? And, you know, and some of them might have JDs, and some of them might cite FCC versus Prometheus to me. And it's not unuseful to me to have the Supreme Court do what it did in Ohio v. EPA, and I can say, see, look at what the Supreme Court just did. This is why I'm not doing this to be annoying. I'm doing this to help ensure that when this rule gets out, it's as defensible as possible. Yes, we have to trade off resource issues. You know, nothing's going to be perfect. We're never going to eliminate all risk. I think this is not a talk about like the role of the agency general counsel. I think a lot of agency general counsels think of their job as eliminating all risk. You can't do that. But I think it's important when the court does something which is sort of extreme like this to show the client this is why we're raising the concern about risk. And I think it has been useful in that regard. But if courts did that a lot more than they do it now, it would be really, really bad for effective governance.
So we're going to encourage you all to ask questions, right? We don't want to be the only ones to be able to pose the questions. There are 2 microphones at the front of the room, so people can start coming forward if they'd like. And as you do so, we'll take some moderators' prerogatives. I can't resist one. This might seem from out of left field, but I'm always trying to learn at these forum-type events, and so far I have 2 law review articles. EPA is the gunner, and HHS is the nitpicker. And I think I'll write both of those articles, so don't steal
Sam
my...
is the nitpicker.
Yeah.
I mean,
Sam is, okay, Sam. But in seriousness, the question is, like, if you had, so Noah and I had the opportunity to think we have we can ask the questions that are on our minds of these 2 experts. Is there any realm in which it would be really good if a law professor / law student investigated or researched X or Y? Anything that comes to mind as you all bring your other questions forward?
I don't know. That is a great question. It feels like there is so much. There is so much, yeah. I'm going to think about that one. I want to see what Boris has to say about that.
So, I mean, maybe one thing I'll say is I was kind of surprised to learn that this whole sphere, where there's been a lot of theoretical work written, maybe has a bit of a dearth of empirical work. And I say that actually in a way by way of complimenting the Institute for Policy Integrity here. With full disclosure, I've been serving in various capacities for a long time. But what that institute did, which is here at NYU Law School, is did some empirical work during the Trump administration, just about the rate at which the agency succeeds or fails in the courts, which became a widely cited set of statistics. It seems like a kind of obvious thing now, but I don't think anyone actually did that before in a systematic way. And so I think the more if you're thinking about doing a paper, thinking about some of the questions we post here or other better questions empirically might be a great idea.
Come to the microphones. Or I see lots of former students, and I'm just going to start calling on you.
Yeah.
So come on up and save us all the trouble.
Exact same instinct. We also do have some questions from online, but why don't we take? Since we have some people lining up, why don't we start with some questions in the room, and we can intersperse some of our other reflections.
Hello, thank you all so much for hosting this panel. One way that this suite of cases has been kind of discussed, along with some of the major questions, doctrine, cases has been as kind of a soft return of non-delegation, whether as like a singular doctrine or kind of piece by piece. I'm wondering, first of all, whether you think that's kind of an accurate packaging of this trend, and second, whether you think these cases provide kind of a discernible endpoint as to how far the court might go in that direction. Thank you.
I'll take a stab at just a couple of thoughts. I mean, I think I at least, and I don't really spend that much time thinking of these big thoughts in private practice, but I would group major questions doctrine with the non-delegation doctrine, because in the realm of separation of powers, they're really about the balance of power between executive and legislative. Whereas I think doctrines like Chevron and Loper-Bright, to me, more resound in the balance between the judiciary and the executive. And so I think I think in a way, a lot of these administrative law problems are grappling at separation of powers issues, but it may be different angles or different powers. And then I think the other part of your question was whether we're at a stopping point. That would kind of surprise me, and surprise me for a couple of reasons. I think there are definitely some circuit courts that are trying to charge ahead on administrative law issues, and they're inevitably going to come to a point of overreach relative to the Supreme Court majority, and so there are going to be cases continuing to come up to the court that way. Also, as the court is changing doctrine, a lot of questions are left unanswered. We flagged a lot of these questions during this panel, and so there are going to be circuit splits about those unanswered aspects of the questions, and those circuit splits are going to come up to the court again.
Yeah, so I would agree with all that. I would say, I think of all of these cases as, to a greater or lesser extent, animated by a kind of concern about delegation. Now, how that plays out is different in the different doctrinal areas, and there's now a dispute on the court, essentially, about, is major questions really a baby non-delegation doctrine, or is it just about the way people ought to read text? It's sort of a natural way to read text. I think it's a baby non-delegation doctrine myself, but so I think there is some of that going on, and I think part of it actually gets to the dynamic that Boris was talking about, that it seemed for a while like the court was marching toward reviving the non-delegation doctrine, and there's a reason why the court never really fully went in on the non-delegation doctrine, even in the bad old New Deal cases. And it's because there's no way to make sense of it. There's no way to make a coherent non-delegation doctrine, certainly not one that allows for governance at a degree that we all expect, regardless of where we sit, within the ideological spectrum, at least, within the 95% middle of the bell curve. So and I think that's true about a lot of these doctrines. This reminds me a lot about kind of the early days of the Rehnquist federalism revolution, where you had case after case after case saying the federal government can't do these things, and then that was a huge thing when I was a young law professor, and now people don't talk about it that much because we got to a point where actually pretty much there's a broad consensus that the federal government ought to be able to do certain things that if you really pushed all the way to the conclusions of some of the strictest principles that were sometimes articulated in some of these cases, the federal government wouldn't be able to do. And I think we're going to get there with administrative law as well. The administrative state is something everybody takes for granted. We really don't want to live in a world without it. Now, we can have a lot of arguments about what it should do and whether it's acting in a way that's, abusing its power and or correct according to the law, but I don't think that the most exuberant interpretations from lower courts are going to be affirmed by the Supreme Court, and I think that's going to be where we're going to equilibrate back. Not to the place where we were before, but I don't think it's going to be tearing down the administrative state.
Thank you to all the panelists for being here. I have a question about states. So my understanding is Loper Bright, that does not affect states. APA, like that's federal, so Michigan can have their own deference doctrine like Florida can. But one is, I'm curious, like, do you think that emboldens states? And in what way, or has that train already left the station? The second thing is just in your capacity, in your different roles, to the extent that you need to interact with state agencies, you need to collaborate with them. Maybe there's a federal statute that requires that kind of collaboration, or your clients as well. I'm curious, where do you see state agencies and just state administrative law changing since the last Supreme Court term?
Yeah, well, I mean, I'll just say a couple of things about that. As a person who lives in Michigan when I'm not working in the federal government, and as a person who ran a state agency in Michigan for a couple of years, number one, Michigan actually, as a matter of state law, rejected Chevron while Chevron was still in existence. So we had, you know, the Loper Bright regime for a long time. As a practical matter, I think we'll see this post Loper Bright as well. As a practical matter, what that's meant is, you know, when judges really want to make a decision about what the law means, they will. And when judges get their eyes glazing over because it's too specialized an area, or it's one that doesn't involve enough money or enough of an ideologically inflected question, they'll more likely than not defer to what the agency says. And that's just as a practical matter what they do, because, you know, one of the things about agencies is they deal with kinds of questions and areas of the law and the economy that generalist judges don't tend to deal with a lot. And, you know, judges tend to be very certain of their ability to decide things, but also don't tend to want to take the time to really dig into complex administrative regimes where it doesn't seem to matter hugely. Now, in the big ideological cases, in the big money cases, that's different. And I think we see that in the states, and we will probably see something like that post-Loper Bright as well in the feds.
Yeah, I think the only thing I would just add is that, you know, I think we spend so much time focusing on the federal government just because it is you know, such a major presence in regulation, but experimentation by states with these various doctrines, and just as the questioner said, they're not really bound by and large by federal precedents here, would actually be quite useful.
So, hi, thank you for this very interesting discussion. So my question is related to science, because now what's fueling the content of statutes, especially in the environmental realm, is model-produced scientific knowledge relied on by administrative bureaucrats to make informed decisions. So these models are very complex. So administrative agencies, EPA in particular, engage deeply in a highly institutionalized way with technical experts, scientists, engineers, to make sense of what they should be doing with what kinds of consequences. So, you know, of course, this is subject to criticism of technocracy. But, you know, court bringing itself into this game doesn't seem to address that question, because courts themselves are, you know, they have these issues of democratic deficit and competence issues. So my question is, what's the implication of overturning Chevron on the role of science in federal decision-making or in legal governance in general? Yeah.
I'll
Go
just
ahead.
make
Yeah.
a couple of quick observations. I mean, I think this harkens back a little bit into the discussion we had about questions of law and questions of fact, and the cases about abortion drugs are a good example of a case in which it seems like district court could quite fairly be criticized for wading into science in what I think many think is a quite ill-informed way. So there's something troubling about that. But I'll just say one thing on the other side, more from a perspective of a practitioner, not exclusively an administrative law practitioner. Explaining to courts and juries very complicated things that they don't know the first thing about is like much of what litigators do. And so it's not like this is the first time this problem has come up, right? I mean, virtually, you know, like in my antitrust practice, every class certification motion involves some bizarre statistical, you know, nuance that you have to educate the judge about. And, you know, or try explaining to a jury what economics of two-sided markets are. Well, these are, you know, this is what litigators do.
I want to add just a little push onto that question, because there have been some musings, at least by academics, about how some of these models now are increasingly reliant on technologies, including artificial intelligence and the like, and what will that do to the kind of reasoned decision-making by agencies, challenges there too? Is that, I wonder if that particular technological issue is one that either of you has some thoughts about.
I mean, I think artificial intelligence is something we're all increasingly dealing with in various ways, and I think we are still, you know, so speaking as agency counsel at the moment, if we were to use an artificial intelligence-based model for something that is the basis of a rulemaking or the basis of a decision, I think it's going to be very incumbent on us to do the explanation of how that model works and why we trust that model. I think there is a lot of the discourse around AI that is very, very much in the vein of, it's a black box, it knows, you can't know. And in like the Ohio v. EPA world, that's not going to work for us. Artificial intelligence, you know, I mean, depending on how you define artificial intelligence, we all use it every day, but, you know, artificial intelligence of the kind that people are worried about and thinking about as problematic, you know, can be incredibly useful to us as a tool, you know, both for modeling various effects of regulatory interventions, for dealing with some of our obligations within the administrative process. But I think we realize that we're going to have to do a good job of understanding ourselves what it's doing, not just taking this tool off the shelf that someone's offering us, and explaining why we trust it. And again, not just by a deference to authority kind of argument.
Hello, thank you all for coming. Nice to see you, Professor Sharkey.
Wow, you have extra time for your
Yeah,
question.
yeah. So a question that I've sort of wondered, and this is a less technical question, this is a more broad narrative question, is, you know, I feel like the debate is generally posed as judges versus regulators. And I feel like a difference that's sort of, or a fact sort of elided in that is that unlike a regulatory agency, a judge doesn't initiate any action on their own. You know, a judge responds to an action from a private party. So I'm curious, why do you think it is that the narrative has been framed as judges versus regulators as opposed to regulated parties versus the administrative state?
Yeah, that's a really interesting question. I mean, I think you could frame it in lots of ways, I guess is what I would say. And you know, there's obviously a kind of ongoing interaction between all of these entities, between the judges, the regulators, and the folks who are regulated parties, or the folks who aren't regulated parties but have some interest in the administrative state doing something that it's not doing, or not doing a thing that it's doing. All of these entities are talking to each other, listening to each other in various ways. And so probably why you frame it one way versus another depends on your interest in telling the story that you want to tell more than anything about what's actually going on would be what I would say, which is probably consistent with what was on your mind when you asked the question.
And I think in a lot of these stories, if we have to point to where the story began, it's often Congress. There's so much regulation is in response to statutory deadlines or statutory grants of authority. I mean, jargosy and all of the cases about administrative law judges at the SEC are essentially, consequences of the decision in the Dodd-Frank Act, back in 2011, to give SEC some of this extra administrative authority, which, really put the targets of SEC enforcement on the back foot, saying, and I've certainly had clients come to me and saying, like, can you get me into a real court? And so there's been a ton of litigation challenging the appointment of ALJs, challenging the tenure of ALJs. I brought some of that litigation, but all of that began with Congress.
Can I actually,
Well, I was just going to say, since you invoked Congress, we had a question that was submitted online. Do you want to read it, or did you bring the question?
I did, but I had a
Okay.
different question about the narrative.
All
Do you
right,
want me to
but
do the
let-
online question?
Yeah, I just want, I think the online question was something about, like, how do you think Congress might respond to these various changes in administrative law decisions? But did I encapsulate it?
I
Something.
think there was a question about whether there are non-judicial paths.
No, so
No.
let's just ask, someone did ask about Congress. I don't know the precise, but sort of, what, in your mind, are there particular steps that Congress might take or might be more emboldened to take in kind of response to these so-called landmark administrative law decisions?
It's a really interesting question. I mean, I will say, in the months since these cases have been decided, we've obviously, in my agency, had a lot of conversations with folks on Capitol Hill about these questions, about how to respond, both in general and when working through particular legislation. I think, there are 535 people in Congress, and they all have different views about what they want to do. I think one of the issues with Loper-Bright is that, ambiguity, statutory ambiguity, is endemic in the legislative process. And sometimes that's because people really should be thinking harder about the language, and they actually could. Sometimes that's about, bounded information, bounded rationality, and so there's just a limit to how much harder they could be thinking. But, the two other important ways in which we get to ambiguity in statutory language are sometimes it is just the best they can do to get to a deal, right? Like at some point, just the negotiating space runs out and everybody agrees the best we can do is fight for another day on what this language means. And it used to be the background rule was, well, the agency's going to decide in the first instance, and now it's a court's going to decide, but we're still going to have that ambiguity. Obviously, if you knew the agency would decide and you could have some control over the agency, like if you were, the chair of the committee that confirmed or that was the appropriation subcommittee for the particular agency, you knew you'd have a lot of influence on how they would resolve that question. Now you don't have that much influence, and so maybe they want to, maybe that changes the bargaining position somewhat, and that might mean more legislative deals get cut with more specific language, or it might mean fewer legislative deals get cut, we don't know. The other reason we have ambiguity is just the rules of Congress. If, and this is sort of a version of what it takes to get a deal, so much legislation now is done through the budget reconciliation process, which has this Byrd rule, which means everything has to be connected to raising money or spending money or something budgetary. And so the most significant legislation that was adopted in this administration, the Inflation Reduction Act, was adopted under those rules. One of the things that we have been doing is implementing the drug price negotiation provisions of that law. There were provisions that would have made some of what was in that law clearer that got eliminated in the so-called Byrd bath. And so now in a post-Loper-Bright world, we don't know what to do. So what can Congress do about that? Well, again, they have to respond in light of who has the bargaining power and what are the rules that apply to them. I wish folks could get more educated more quickly on Capitol Hill about things like JARCISI and about the risks of civil monetary penalty provisions, for example. But again, the Chadha example suggests that's going to be a long process.
I just wanted to come back to the framing question that we had over here about the judiciary and the pressures, because one story, and this is a legal historian indulgence, so you'll forgive me, would have been that it's not about Congress, despite the fact that, yes, Congress passed laws, but throughout the 60s, 70s, 80s, and 90s, Congress was still passing laws, but we didn't see the kind of climate that is being reflected in these decisions then. There have always been anti-administrativists, but it's not until, 2017 that Gillian Metzger writes that foreword in the Harvard Law Review called 1930s Redux about the challenge to the administrative state. And you could even point particularly and say, wow, after Chevron has decided, the Federalist Society, well, it's not really a big thing yet, but being a conservative jurist doesn't mean being suspicious of agency adjudicators. Famously, Antonin Scalia had been a professor of administrative law before he became a Supreme Court justice, and he remained a fan of Chevron until pretty late in the game. So one story, a historian's story about why this is judges versus the administrative state and not regulated parties against the administrative state, is that the real actors here are the judges. That really the only change between the 90s and today is that in the 90s, Reagan judges and Carter judges were on board with a constructed interpretation of the APA coming out of the 1970s, whereas the new Federalist Society judges, whether they were W. Bush appointees like John Roberts, who then got Philip Hamburger's religion after reading his book on the administrative state, or Neil Gorsuch, son of Ann Gorsuch, who's both a Trump appointee and an anti-administrativist from the womb, or at least from whenever he's sort of training with his mom, that they're the ones driving the change here. So both of you have a very different perspective on this fight. You're not, and then maybe the last twist would say, so somebody like Professor Philip Hamburger, who I've been on a panel with, Philip, if you're watching this, I love you. He's set up something called the New Civil Liberties Alliance, which is an ideological nonprofit that is closely connected to some of these same tendencies. So one story would be, the only thing that's changed here isn't the clients, it's not even the regs, it's that a particular ideological change has created a different environment in the judiciary, which in turn calls forward different plaintiffs. So the kind of, to put the question to you on a sharp edge, is that wrong? Is that story missing something? As you look at this from your perch in an agency or from your perch in private practice, do you see a change that is attributed to that factor, or no? I'm exaggerating. Really, Noah, the truth is, it is the fact that Dodd-Frank's overreached and that now you have this aggressive SEC. No, Noah, it's that HHS should be more nitpicky, and 40% of the economy, 40% of regulations covering a huge fraction of the economy is just a lot more now than it was 20 years ago.
I mean, look.
I'm going to predict what the response is.
Here's what I'm going to say about this. I am on leave from my job as a professor at the University of Michigan Law School. I am planning to return from leave, at some point, and when I return, I will have a very interesting answer to your question. That's what I'd say about that. Look, here's what I know. I think you could tell the story in a lot of different ways. One thing I know is we live in a world now where the law that governs us as a practical matter, as an agency, has changed. That there is at every stage of the process of challenging administrative action, the opportunities to challenge administrative action have been expanded by judges, not by Congress, by judges. So the way judges have dramatically expanded the way they think about standing, notwithstanding that we've won some important victories fighting off the most expansive interpretations of standing, like in the Alliance for Hippocratic Medicine case. Nonetheless, the rules governing standing are interpreted much more generously now when you have ideological plaintiffs challenging progressive governance than when I was representing civil rights plaintiffs challenging states that were violating people's civil rights. Make of that what you will. We have much more broad interpretation of what is final agency action than we had in the past. We have much narrower, and I would say atextual or even anti-textual interpretation of what is good cause to avoid notice and comment in a rule than we had in the past. Read the text of the APA and what it says is good cause to avoid notice and comment, and then compare that to the cases that say that good cause did not exist, and explain to me how those judges can call themselves textualists. That's what I will say to you. So we experienced that. And I could go at every single point, so again, Ohio v. EPA is an example of, well, what is arbitrary and capricious? That's being read in a very broad way by a lot of courts. Again, a lot of courts don't, a lot of courts do, but if I'm in certain courts in certain parts of the country, I know that that's going to be read in a particularly broad way. And so there's no way to divorce this story from the judges. Now, is it just about the judges? Is it, I think those are really interesting questions that I'm really happy to give an answer to when I'm back in the academy. But of course, the judges matter.
Did you want to say anything?
I'm just married to a law professor.
Some of your very good friends are law professors. I'll
That
remind
is
you.
true. That is true. I guess the only mildly intelligent thing I'll have to add here is I think it's very hard. It is about the judges, but how does that come about? I think is a very hard question to answer, and maybe some of it has to do with the general deterioration of understanding of the role of government and the role of our civic institutions, and having kind of come into my U.S.-based political conscience during the Contract with America era in the mid-'90s, and then having served in government during the Tea Party, at some point you listen to the "Get your government hands off my Medicare" speech, enough, and you wonder whether some of these problems just need to be cured through education.
Do you want to go ahead?
I had a question that's pretty closely related to some of what's come up already, but it's more specific to the budget and appropriations context. I'm a former budget analyst at education. And so, I know I observed sort of firsthand that where you have authorizing statutes where there's trouble getting anything passed, annual appropriations acts often serve as a stopgap, and there is statutory language within that lapses, like the money associated with it lapses a year after enactment. And I'm wondering if the Loper-Bright decision may have a more, or if you think there's more of an impact in that setting where laws are enacted more frequently and the time that the money is available is limited. So where an agency's decision, if it doesn't hold, the money may go poof, essentially.
I think I haven't really thought about that. That's a really good and tough question. I think my struggle is that a lot of Loper-Bright type decisions are about the authorizing language rather than the appropriating language, because appropriating language is rarely, the source of the agency's authority. And so I think we'd have to think hard about particular instances when that really comes to bear.
Yeah, I think that is a really interesting question. Very often, the appropriations law issues that Boris and I both dealt with at OMB, and that I still deal with a lot at HHS. Those are not justiciable. It's really us trying to figure out what we think is the best interpretation, knowing that there might be congressional oversight, there might be GAO responding, but it's not usually in the shadow of litigation in the same way. And so, how you think about Loper-Bright in that context is an interesting question that I'd want to think more about.
So we have a hard stop in about 6 minutes, so I thought I would give our panelists one last opportunity to reflect or share any thoughts they might have with our students. Maybe the small prompt I'll give is, we've been living through this shift. The last term was a momentous one for administrative law, but hardly the only term recently that has seen big administrative law cases. We have an audience here in person and online that's very interested in the direction of administrative law. As you think of any last words for our panelists, our audience, you if you have any advice to offer them or guidance as they continue to follow developments in administrative law, I'm sure those would be appreciated, but I don't want to canalize you into that.
Well, I mean, as I said at the beginning, I'm really serious. I think it's awesome that there are so many people who are interested in administrative law now. How that became sort of a cool thing, I don't know. But because it was always sort of a nerdy thing, which I liked. Now I feel like I'm going to the popular part of town, and it's making me a little anxious. But I would say about that that it is. There is, if you care about effective government, then you need to care about administrative law, because it is the thing that structures how government can or is stopped from being effective in this country. I would say there is a way of studying administrative law where you become sort of an APA maven, and that's great. Like, I got no problem with that. But I think to really understand administrative law, and this resonates a little bit with what Boris was saying about empirical scholarship, I think, as a student or as someone who wants to really do work in this area, there's just no substitute for kind of getting into some agency that's doing a lot of stuff and working with the folks who are actually trying to carry out policies, make and carry out policies, but really it's the carry out and implement. That's what you don't get enough of in a classroom. You don't get enough exposure to, in an academic setting. And, where administrative law does its work is as much like in the bowels of the bureaucracy, which is also where the government actually serves people, than in, as in the courtrooms. And so, doing that kind of work in a government agency that's actually trying to do something, whether that's a federal agency, a state agency, a local agency, I would encourage you, if you're interested in this kind of stuff, don't just like go work at DOJ, but like try to find a job for a while where you're really working on a program or assisting someone closely on a program that's trying to do something.
No, I agree with everything Sam said, but you certainly relate to admin law being kind of like a nerdy thing. And what brought me to this nerdy thing is that it is so tied to other things I'm really interested in, history, politics. And while, we spend a lot of time parsing doctrine, I'm also mindful we're a month away from an election. And a lot about the course of where administrative law is going to go in the future is going to be about what happens. And it could be, it's not just a blue or red thing, but also about, are we going to live in an era of divided government where a lot of policy work is going to be done through executive actions, perhaps under tenuous legislative authority? Or is it going to be an aligned government where we're going to see some major legislation that, just like some of the statutes we talked about today, Affordable Care Act, Dodd-Frank Act, those all came from that short period when President Obama had Democratic Congress. And are we going to see more of that? And is that going to drive the next wave of changes in the law and the next cases?
Wonderful. So please join us. We were really fortunate to have the time of both Boris and Sam today, and please join us in thanking them.